Okay, so welcome back, everybody. I really want to thank and introduce my guest here, Chip Stewart, a professor at Texas Christian University. Chip, do you want to kind of just give a little bit of background to the students, not only on what you do in your day-to-day and how you got there in your career, but also maybe mention a little bit about how you've talked to a lot of different audiences about these legal topics?
Yeah, sure. So my background, I was started as a sports writer. I did some PR work. I did some journalism work. I went to law school and at University of Texas. I practiced law for a couple of years before returning to newsrooms as an editor and as a writer as well. And then I went while I was there. I started teaching. I was at University of Missouri. Really enjoyed it, and so I ended up finishing up my PhD, focusing on journalism and law, communications law, and that sort of stuff. So I've been here at TCU for coming up on 14 years now. I teach our law classes, so media law and ethics. I also teach our sports writing classes here. And in that time, I've talked to a lot of groups. I talked to like journalism and press associations, kind of little small regional ones around here. I work with freedom of information, open records, open meetings groups. We have what's called a certified public communicator program here at TCU that works with like city and county spokespeople for like law enforcement, school districts, that sort of thing. So public information officers. So I teach sessions on that. I've taught journalism students, ad PR students, and I do just some consulting as well at helping out advocacy groups, again, lawyers, other people, and a lot of times just like journalists and communicators with questions they might have on open records, open meetings. I get a lot of questions about copyright, and I have a lot of students who start businesses, and I'll help consult them on whether it's like how to make sure people have their ownership stakes laid out in their founding business documents. And I'm dealing with that right now, and making sure they protect their trademarks and copyright and that sort of thing. So and a lot of my interest in the past decade has been in social media law and communications. And so I've tried to make sure we stay up to date on all the new ways we communicate and the challenges those present.
Yeah. So I wanted to just kind of highlight some of the key areas that we're talking about in the class this week. And I'll provide a little introduction to reference for the students some of the material that's already been introduced in the video or in the reading or in the audio clips. One of the first areas we're dealing with here in week 2 is intellectual property law. And I wondered what came to mind, Chip, when we talk about, the audience of professional communicators, folks who are working either within an organization, an agency, typically. What comes to mind for you of what those folks need to know about things like copyright, trademark, and patent?
Yeah, sure. It's interesting when I took a course like this, a media law course, it's coming up on 30 years ago at this point, we didn't spend 1 second on intellectual property. Like, it was all defamation and privacy. Like, the whole course was defamation, privacy, prior restraints. And it's probably the most pervasive thing that we deal with now. I could teach a whole course on it. It's just so necessary to know if you're a professional communicator. Because basically every time you publish something, you run the risk that it's, if it belongs to somebody else or somebody else thinks it belongs to them, you're on the hook for a bunch of damages, right? And just like living life right now is an act of communicating. If you're on any social platform, you're sharing, and somebody owns this content or took that content somewhere, and the damages can escalate pretty quickly on them. So a couple of things to think about is, both, how can you use things safely? That if you find it somewhere and you want to share it, you want to use it professionally. And the other is, how do you protect your own works, right? To make sure that they are being used in ways you want. And some of this starts with, just knowing like the basic terms and the differences, knowing the difference between a copyright, which is, federal law, gives you exclusive rights on works of authorship and fixed medium of expression. So photos, videos, audio, text, those sorts of things, you create them, you own them. Somebody else creates them, they own them, and you probably need permission if you're using them for profit or that sort of stuff for commercial purposes, with the exception of fair use, right? Which gets complicated. And I can talk about that a bit too. Trademarks, to distinguish from that, can be state or federal law. They're really about brands and marketing and identifying the origin of a business, a product, a service, something like that. They are distinct. They're not the same thing. Sometimes they have a little bit of overlap, but I see mistaken headlines all the time that conflate copyright and trademark, and they're just different things. So knowing what you're dealing with in the first place, to think trademark, branding, marketing, that sort of thing, where copyright's more about works, text, video, photo, that sort of stuff, and patents more about, you know, inventions and that sort of stuff, also related but distinct, also federal only on those sorts of things. And one way I like to illustrate it to my students is like, you know, you got one of these guys, you've got a cell phone, got a smartphone, your little Apple logo there, right? So that's going to be a trademark. A little OtterBox, I'm clumsy, so I dropped this a lot. You know, that's going to be a trademark, but the OtterBox itself is a patent. This thing is just chock full of patents, including the switches, the plugs, the rounded corners. Those are all patents, design patents, that sort of stuff. All of your apps, the icons are going to be trademarks. The content in them, the photos, the audio, the video, that's all going to be copyrighted, right? So the Twitter bird, trademark. The tweets you get, copyrighted most likely. So just, you know, understanding some of the basics of those sorts of things. That's at least where I like to start.
Yeah, I think that's a great place to start. And you're exactly right. You know, similar in a lot of the media law classes I've taught over the years to various student populations, until really the last 10 years, intellectual property was a foreign concept. And I liked how you kind of said, you know, in terms of digital media and the world we're living in, it's now ubiquitous. It's been a really big switch on those fronts. What is it about, you know, you mentioned kind of the terminology and things. If you're thinking about someone who's working in a communication capacity, maybe they're working in a project for their organization, or they're working with a client, and an issue is going to come up that touches on intellectual property, but they're not a lawyer, they're not an expert. What advice would you have as far as when they need to involve somebody in a legal department? Because you mentioned really the two-sided coin there, right, of protecting your own rights, but also not making violations. Do you have any kind of recommendations for that?
Yeah, sure. I think let's start from the creation side. So you create a work and you want to protect it. A couple of things to know is that copyrights automatically attach at the moment of creation to the creator. So you take a photo, it's yours. Now, if you're working full-time for an agency and an employer, it's probably theirs. It's probably the agencies or the organizations. If you're working full-time, if you're a contractor doing work for hire, if you're a freelancer, for example, the default is you own that, not the person who hires you to do it, but you can have a contract to the contrary. This is really important to set up in advance. You're a freelancer, you're a contractor, do what you can to control your work, or make sure if you're selling it in full that you know that and you've got that clear in advance. These disputes pop up all the time. But again, if you're working for an agency full-time, chances are they hold the copyright. If you're a journalist, you write a story, they have it. If you're a photographer, they own it. So they're the ones who can control those rights. But understand that the right attaches immediately. You control it. You don't have to go register it, though. If you actually want to go to court over later on, you do need to go register it. But the way American law works is the copyright's just automatic. You can backdate to the moment of creation. So on that side, just, you know, if people are using your works incorrectly, you have a number of things you can do about that. It could be a time to talk to legal if somebody scrapes a story from your site and puts it on theirs, right? And the remedy you might want is to tell them to take it down, right? It might be to attribute it to you or give you credit. You might want to have them pay for it, right? Because typically people would pay a license. So those are all options you would have if somebody has taken a work of yours, a photo, a video, something that you did that you own and you feel like you should control. And that includes being able to take it down. One thing that's important to know is the Digital Millennium Copyright Act, DMCA. Basically, every website, everything that hosts, including social media platforms, will have a DMCA provision that will give you an opportunity to take things down that you think belong to you. That way, they don't want to get sued for being what we call a contributory infringer. So you can send a takedown notice, or even these, they just like press a button, like file a complaint form. Yeah. And YouTube, Google, none of these places want to argue about this. They're mostly just going to take things down. You can get into arguments about fair use and that sort of thing, but practically, if you need things down, that can be a good way to do it. So that's on the creator side. On the user side, advice, whether you're journalism, ad, PR, any type, just blogging for fun, whatever, start from the perspective that if I didn't create it, I don't own it and should be really cautious about using it. And it is a time to stop and think, like, if you share on a platform, say you're on Instagram, and well, I think Twitter's a better one for sharing, but you see something, you like it, you retweet it, right? You quote tweet it, something like that. You retweet with a comment. that's fine, right? You're just sharing within the bounds of the platform. If you copy something and move it from one platform to another, at that point, you're not sharing anymore. That can be a taking, that can be a infringement. So see something like on Instagram, you screenshot it, you move it over to Facebook, even though they're the same company, they have different terms of service, different user arrangements, and you might be infringing there. If you're doing anything for commercial purposes, right? Photos, video, that sort of stuff, ask permission, because again, if you infringe, they can shut you down, they can take things down, or they can sue you. And again, the damages can get pretty high.
Yeah, I think you've summarized most of what my recommendations would be there as well. And just to mention, if somebody's unfamiliar with it, tons of either free or low cost or relatively low cost services. If you're looking for photos or things that companies and organizations use all the time. Of course, there's Creative Commons where you can find some free or where folks have kind of declined to enforce the copyright, but Shutterstock, like there's tons of different
there's things you can buy licenses to out there. It's one of those, like, get permission, buy a license. You're going to be a lot safer there than just using it, because the damages, you might pay $100 to use a photo, but the damages might run $1,500, $2,000, $10,000, right? If you use it, get sued on it.
Absolutely. Well, from one notable area of law that digital media has brought to us to the second, the middle module of this week, we covered defamation a lot. And one issue that I addressed in the material the students read and watched, but has also been in headlines related to social media and Google is, Section 230 and how that works in terms of reputation and the internet. And I found it interesting, Chip, as we were talking kind of before we started recording the video, this has come up for you in conversations you've had with other groups you've spoken with who ask questions about Section 230, and sometimes the answer's sort of simple. So what advice would you have for the students on what they need to know and what, if anything, they should be worried about with Section 230?
Yeah, I did a webinar for 3CMA. If it's the City County Communication and Marketing Association, something like that. It's basically an organization of city and county spokespeople. And they wanted to talk about 230 because it'd been so much in the news, and there's a lot of multiple legislative efforts right now to reform or repeal it. It has been called by the author and scholar Jeff Kosseff the 26 words that created the internet. The one provision that remains from the Communications Decency Act. The rest was struck down in 1996. And so people knows, like, what does this mean for me? And for the most part, it means nothing to you. Like, it practically, for a communicator, or the things it means for you are all really good. What it means is, if you're an internet service provider or an interactive computer service, this includes, like, you as a web host. So if you have a web page and a user, somebody comes on your web page and does something that hurts somebody, you're not responsible for it. That's basically it. That platforms, from as big and high and mighty as Google and Facebook and Amazon and these sorts of groups, to you have a blog, right? And somebody comes into your comment section and libels somebody, you're not responsible for that defamation. That they're responsible for it. So Section 230 basically says that platforms, interactive computer services, are not responsible for the acts of their users, and that includes privacy violations, defamation, that sort of thing. And it does not include copyright. It does not include criminal law. Copyright goes over Digital Millennium Copyright Act, whole different thing. Does not include any criminal provisions. That's, again, whole different thing. But for most of the torts you have for online activity, or for a communication activity, defamation, privacy, they're immune from it. And again, that's for good or ill. It means somebody goes and says something false about you on Facebook, you can't sue Facebook. You can sue them, right? It means if there are anonymous gossip that goes on, it can be hard to find the person. The company may have to help you find that person, but you can't sue Twitter or Instagram or Google and make them a party to that defamation. Whereas if you've been learning about defamation, there's usually the republication rule, right? That a newspaper is responsible for everything it publishes, even like the quotes. If somebody says something false in a quote, well, yeah, that source is responsible, but the newspaper is responsible too. Section 230 online says you're not responsible for the acts of users if they just come on and say bad things in the comments or that sort of stuff.
Yeah. And I think the other, just to round that out, I mean, the other big way that's come into the news that people may have questions by is it doesn't, however, preclude a social media platform, a website, a blog from having its own terms of use and
Oh, yeah.
enforcing that, right? So I think that's the other point of confusion was somehow, I think somehow the political argument's been made that they are somehow a public speaker because they're large
They're
and
moderating,
have
yeah.
influence. But that's a distinction we've covered reaching back to the first week of class, which is they're a private entity and so not subject to the First Amendment in those same ways.
Yeah, exactly. That, it's interesting. There's this provision in 230, and basically the whole point of it was to encourage good moderation practices. That it was to say, hey, if you're, I mean, this goes back to the 90s, so it's Prodigy and CompuServe and these sorts of America Online were the cases. And those of us, ancient internet users, they used to, use dial-up and stuff. That was our jam, right? But they wanted to say, look, if people are posting things on bulletin boards or chat rooms and they're bad, you can take those down and you're not responsible for that, AOL. But if you don't take it down, you're also not responsible. So because people were concerned, that if you're moderating it, then at some point you're taking away people's free speech or that sort of like, and they said, no, not at all. We want to encourage good moderation practices. So yes, you make the policies, you take them down. You're not going to be responsible for those choices. And if you do nothing, you're also not responsible.
Yeah.
And that's, you're right. That's not even so much Section 230, right? That's the First Amendment.
Yes,
government,
exactly.
hard for the government to come in and say, here's how you should do moderation and allow people on your platform. That's not a 230 problem. That's a First Amendment problem.
Yeah. The final module that we cover here in the second week concerns privacy. Some of that is kind of comparing and contrasting the United States concepts of privacy with many other countries around the world. Specifically, we spent some time on the GDPR. And I think that's a good place to start because with business, that has really influenced things, even how American companies have to operate if they have users abroad, particularly if they're doing business in the EU. What comes to mind, Chip, when we kind of talk about that comparison, which is almost a dichotomy of these different ways of thinking about privacy online?
Yeah, another one where we maybe spent a week or two on privacy when I was taking a class like this many years ago. You could do a whole course on privacy, obviously in the digital age and we're worldwide all the time. Everything you publish can go just about everywhere, except China. They block about everything. But Middle East, China, they don't allow a whole lot of stuff. But yeah, a lot of this is that when you're publishing things, when you're communicating, you are subject to the laws of wherever that stuff is being communicated. So it means you do need to be aware of the data practices and the consents required in Europe, for example. If your users there, they're going to have a lot more right to know how you're using their data, what you're using it for, give explicit permissions, more like opt into data tracking rather than having to opt out of data tracking, that sort of stuff. It's not just Europe; it's starting to happen in the United States as well. That California, for example, has a new user protection and data privacy law, and other states are starting to model it. Kind of the failure of the federal government to do anything meaningful in this area. There have been efforts on users' Bill of Rights and that sort of stuff. None of it's really gained any traction. So states are starting to pick up the slack again, for good or ill. And if you're doing business, you may need to know, like, what is this? If you're, for example, I live in Texas, so if we're in Texas, but we have customers in California, we're going to be subject to California laws for our customers in California, and you may have to do different things when it comes to notices and opt-outs regarding and tracking that sort of stuff regarding your clients or your users in California. So yeah, it's just being aware. The sort of things to be aware of are what do you have to disclose? What do you have to be transparent about? What do people opt into versus having to opt out of? How explicit do you have to be in your terms of service? And a lot of this really is about kind of transparency, notice, that sort of stuff, making sure people know what data you're gathering, what you're going to be using it for, how long you're going to retain it. And then you really got to stick to those sorts of things. Where companies get in trouble is when they don't keep those promises or they breach them and they get hit by the Federal Trade Commission, right, the FTC, for violating these data privacy promises. And everybody, Snapchat, Facebook, Instagram, they've all been hit with by those companies or by the FTC pretty hard over the years.
Yeah.
Google as well. Yeah.
The final area I wanted to ask a question about also is in this privacy, and it's the subject of what the class will be exchanging posts on the discussion board this week is really, and it's again one kind of ripped from the headlines here that we've been experiencing, which is a mass kind of public misunderstanding and distortion around HIPAA and what it is, particularly as it applies to COVID-19. And that in particular, I'm interested in for this course in terms of what the rights and responsibilities of employers' employees are. wanting to do the right thing, wanting to respect, even if it's not law ethically people's privacy, but also needing to know information to kind of make a workplace run. What kind of comes up for you when you think about this thorny issue of HIPAA and COVID-19?
Yeah, sure. Well, first thing to remember about HIPAA is it is HIPAA, right? So you sound foolish if you do a two piece. It's not a hippo. So Health Insurance Portability and Accountability Act, right? That's HIPAA is what it stands for. My wife's a physician, right? She's a pediatrician, so they're the people who really have to deal with HIPAA stuff, right? Which is if she's on a computer logging into her network to do remote charting and that sort of stuff, there's special encryption protocols they go through to log in, that sort of thing. Because really, this is about protecting patient privacy, and it's about healthcare organizations protecting patient privacy. So HIPAA really only applies to people who are healthcare providers, so doctors, nurses, clinics, health insurance companies, hospitals, that sort of thing. It might apply to like emergency services, which are generally independent contractors when they transport people. But for the most part, it doesn't apply to any regular people outside the health profession. So if you are managing patient data at all, you're going to be subject to HIPAA. And some of that is obviously not revealing things you're not supposed to. Don't sell it to marketers or anything like that. Don't leak it out. That's why you sign all those forms when you go into doctors' offices about who they can share these things with, like even a parent, an emergency contact, those sorts of things. So, I mean, that's the big thing to remember about is like, it's really about healthcare organizations and what they are allowed to communicate, or more importantly, what they're not allowed to communicate about patient information. If you're an individual person, HIPAA doesn't apply to you. Like, so you can volunteer information. If you're a private business, HIPAA doesn't really apply to you, right? So yes, you can ask for people's vaccination status. You don't have to, but you can reveal it. Again, I'm here in Texas, so I'm a lifelong Dallas Cowboys fan. Sorry if that disappoints some of y'all, but when Dak Prescott, the quarterback of the Cowboys, came out before the season and said, "Oh, I'm not going to talk about my vaccination status, that's a HIPAA issue," it's just patently absurd, right? That like, you're not a healthcare organization. The Dallas Cowboys aren't a healthcare organization. That you can say you're vaccinated, you can say you're not. You don't have to. You can stay quiet. HIPAA has nothing to do with it. Now, the Dallas Cowboys trainer, if he's a medical professional, maybe, right? You can't force him to say things, right? If he were to reveal things, maybe, right? Maybe HIPAA gets implicated. But no, that businesses can ask customers about vaccination status. They can ask them to wear masks. They can tell them not to wear masks, right? It's like a private business. You can control those sorts of things. Anything short of like discrimination based on race or gender or age, ethnicity, those sorts of things, you can't do those. That's federal law issues. But
exactly. And I think that's where we get into it in the module, is when you do get in the workplace accommodation, for somebody who either has to work remote or the reasons behind that, what you disclose even within the office. There's some step-by-step guidance on that, but to kind of reiterate your point, that is a separate conversation, right? From HIPAA.
Yeah. And you may be more in the ADA area at that point too, what you can share, what you have to accommodate, that sort of stuff. But HIPAA is really, it's easy to worry about something because so many people have been talking about it.
Yeah.
Unless you're in the healthcare field, it's not really a big deal for you.
Yeah. Well, that concludes everything I really wanted to ask. Chip, as you think back to anything we've talked about here over the past 20 minutes or so, anything just to conclude, or any parting words?
I'm trying to think of anything. I'm a big fan of the First Amendment, so go out and defend it, right? That's one of those things that I think we take for granted, that communicators are often the people most kind of implicated on what First Amendment freedoms mean, because our job is speech and press, right? Our job is communication. And there are forces out there that right now that are not big fans of that sort of freedom. And it's people like us who stand up and advocate for this. So whether you're a parent, a teacher, a parent of a teacher, right? You just want to go to your school board meetings or city council meetings, whatever. Go have your voice heard and make sure people get a chance to be heard as well. It's really important. Yeah,
I think that's a really important point. And we think about First Amendment so much in terms, either theoretically or practically, in terms of free speech, but it's also the freedom to hear ideas, right? It's all about the free flow of information, which I think sometimes gets tertiary interpretation there of the First Amendment, but also is really important because when you lose some of those, they are difficult, if not impossible, to get back, as we've seen.
Right. A lot of kind of living in a freedom-loving, kind of pro-liberty society, right? It comes with some real challenges to make sure we stand up for those freedoms and liberties.
Absolutely. Well, thanks so much, Chip. I'm going to sign off the video here. Thanks for all your contributions to the class. Really appreciate it. And thanks for making time.
You bet. Glad